الكلمة الآن للأستاذة روزماري باركيت من قاضية بهولندا.
Hello and salam alaikum. Although I have been a judge in every kind of court practically in the United States, I am here today representing Hillary Bass, the president of the American Bar Association, which is a voluntary group of about 400,000 lawyers and judges in the United States, and I am one of those volunteers. The American Bar Association believes and has believed for many years that they have an obligation to partner with judges and lawyers in countries all over the world to learn from them and to offer whatever assistance we could offer in order to advance the rule of law globally. In that capacity, I'm very proud of the fact that we have worked here in Morocco jointly with the judiciary and the various aspects of law here in Morocco, and have for something like 15 years, I believe, participating in many projects, several of which I have been lucky enough to be a participant in. So I was very sorry that President Hillary Bass could not make it, but I was also very glad because it gave me the opportunity to come back to Morocco. And it makes me particularly happy to come to Morocco because, let's see if I can say this in Arabic, Walideya Mensuriya, my parents were born, raised, and married in Syria. So I'm very happy to be in a country that reminds me so beautifully of my own ancestry. So thank you for that. Let me first say, I know what a tremendous effort putting on these conferences are, so I too wish to add my thanks to His Majesty, King Mohammed VI, and the Ministry of Justice for convening this very important conference. It now appears over 2 days from the prior speeches that all of us agree that assuring the independence of the judiciary in any country is essential to a rule of law that values justice, equality, and fairness, and guarantees access to courts as the only viable way to resolve conflicts and to assure that those values of justice and equality before the law are implemented. These goals appear to be universal. However, what that actually means, or the manner of achieving that goal, can differ, and it is only through communication between people in many different forums, including this one, that we can learn from one another by considering different avenues to achieve the common goal of a just society. I am extremely grateful to hear that this is but the first of a continuing and ongoing effort, because as we know, things of value cannot generally be accomplished in the short term. We raise our children little by little, we learn a musical instrument little by little, we become proficient in soccer or tennis only little by little, and we learn about shared concerns and possible solutions to make our world more and more just little by little. And that means answering many of the questions that were raised earlier, especially, if I'm remembering correctly, by the representative from Mauritius and South Sudan, and just recently from a representative from Spain. What is the independence of the judiciary? What do we mean by it? What should be encompassed within it? All of those more granular issues, I hope, will eventually be addressed in future conferences. As I mentioned, I have been fortunate to serve in different capacities in the judicial system in the United States. I have served in the state courts of Florida, including acting as Chief Justice of the Florida Supreme Court. Then I was fortunate enough to be appointed to the federal system through the offices of President Bill Clinton, and served on the appellate courts of the federal system, and then subsequently and most recently through the government of Barack Obama, now serve on the Iran-United States Claims Tribunal, which is one of the international tribunals in The Hague. So my remarks derive from my observations in all of those various capacities. As you have heard, the founders of the United States from the very inception of our country specifically separated our government into three separate and co-equal branches. The idea and the reason for separating out the executive and the legislative branches from the judicial branches is to prevent the excessive accumulation of power by either the legislative, executive, or judicial branches. All three were given the tools to check one another and hold them to their defined purposes. So the legislative branch was intended to be the only branch to make the laws, and the executive branch was in charge of enforcing the laws. And the judicial branch, in addition to resolving disputes between citizens, was also given the power to make sure that no law was in violation of our Constitution. During the debates that my colleague referred to earlier, prior to the adoption of this constitutional system, it was explained to the people that without an independent judiciary, the rights of the minority against the potential tyranny of the majority could never be enforced or protected. The people had to have confidence that judges would be impartial and would make fair decisions based only on the facts and the law without being swayed by the legislature or the executive branch in any way, or be subject to any other outside influence. The way that our founders attempted to ensure that independence was to provide in Article 3 of our Constitution that federal judges would serve essentially for life, during good behavior, of course, and that their compensation could not be diminished. However, I would point out that governmental control is only one way in which the independence of the judiciary can be threatened. The legal system must also protect its judges from other outside pressures that may try to influence them to deviate from the law in a particular case because of fear of personal consequences, or perhaps in pursuit of personal rewards. There is certainly more than one way to achieve a goal, but the end result has to be a judiciary that is competent, but that is also insulated from those forces which would conflict with a judge's ability to decide the case fairly and in complete neutrality. But this also means that there has to be judicial accountability. Thus, there has to be mechanisms that will ensure that judges are neutral, that is, that they cannot be controlled by the state or by anyone else, and that they have no interest, financial or otherwise, in any case before them. Obviously, a legal system cannot permit a decision maker to own shares in a business that is party to a case before them, nor can they be permitted to sit on a case involving relatives or friends. We all know that much, but there are less obvious ways in which a judge's neutrality can be compromised, and consideration must be given to devising means such as a code of judicial ethics or behavior to help establish the parameters of judicial conduct, things which might and are perfectly legitimate for us to engage in as citizens may not be appropriate once we take on the responsibility and the duties of a judge. Such a code would work to maintain judicial neutrality, would greatly enhance the public's confidence in the judiciary, and additionally, it would protect judges from attempts to influence their decisions. We do have such codes of conduct in the United States, throughout the states and in the federal judiciary, and we have additional checks and balances to ensure the judicial accountability that must go hand in hand with judicial independence. We have multi-layered appellate courts within our judiciary and various systems in the state and federal judiciary whereby complaints against judges may be lodged and evaluated by judicial disciplinary bodies. Finally, in order to inspire the public's confidence in the impartiality of the judiciary, we must assure that judges are chosen by virtue of their competence, their sense of integrity, their dedication to hard work, and their willingness to pursue continuing education. Therefore, we have to take care, in order to attract and retain people of that stature, we have to take care that judges are adequately compensated in order to gain and retain the best and the brightest within the ranks of the judiciary. We must not let the legal profession or the business community entice away the best candidates because they cannot make an adequate living in the judiciary, or their stature in a community is not commensurate with the extremely important role that they play in our society. Now, having described what I consider to be a fairly good methodology for maintaining an independent judiciary in the federal system, I do have to point out that the United States does have serious problems in its state courts, as they do not have the protections afforded to federal judges by our federal Constitution. State court judges, unlike federal judges, are not protected from political winds, changing popular opinion, or special interest money by lifetime tenure, or a ban against lowering salaries. Rather, states employ a patchwork of different systems for judicial selection and retention that leave the judiciary vulnerable to attack, and the United States is working very hard to address those problems and to protect our state court judges from the vagaries of politicization. I want to try to shorten this because I know that you've been here all morning. I just want to point out very quickly that, again, we have to remember that the whole purpose of an independent judiciary is to rule based upon what is legally right, which may sometimes require an unpopular decision or position. As the Defense Research Institute stated in 2011, judges must be dedicated to intellectual honesty and must demonstrate the ability to rise above the political moment to enforce the rule of law. Nothing can be more damaging to a society based on the rule of law than if judges fear that they will be removed from their office or that their livelihood will be impacted solely for making a decision that is legally right and factually correct, but unpopular politically. The judicial branch is different. It was not designed to be a political or representative branch. And cultures and laws may differ, but the legal system of every country presents problems that are universal. And I hope, it is my hope, that we can continue to explore the questions that arise in order to assure, in greater measure, the independence of the judiciary that will lead to a rule of law that will lead to a just society. I have to end by saying I have never seen anything like this conference, and I'm very old, and I've been to many conferences. Morocco has achieved already a tremendous amount in simply getting so many countries at their highest levels to think about and to talk about judicial independence, which is a pillar of a just society. No other country has ever attempted to do that or has come close to doing so. So in really no official capacity, but simply as a human being concerned about the protection of all human rights, I really have to thank Morocco for this amazing achievement. Thank you very much. Shukran.
شكرا للأستاذة روزماري على عرضها القيم، وشكرا للحضور الكريم على تتبعكم وعلى إنصاتكم وعلى صبركم. الآن نرفع الجلسة لتناول وجبة الغداء على أساس الرجوع إلى القاعة على الساعة 3:30 لمواصلة أشغال الجلسة الثانية، وشكرا لكم.